What is a license? 1. Understanding the legal nature of a license. A license is legally defined as a personal privilege to perform a specific act or series of acts on land without possessing any estate or legal interest in it. This privilege is typically revocable at the will of the licensor and is not assignable. In legal terms, the license authorizes conduct that would otherwise be illegal, trespassory, tortious, or outright impermissible. Refer to People v. Henderson, 391 Michigan 612, 218 N. W.2d2. A license often involves a governmental authority granting permission, usually for a fee, to engage in activities regulated under the government's police powers. For further reference, see the 9th and 10th Amendments of the United States Constitution, especially the clause, "nor prohibited by it," which emphasizes that rights not specifically denied remain intact and cannot be diminished through constitutional additions. 2. A sovereign society in the nature of voluntary subjugation. Imagine a fictional land where every person is a king or queen in their own right. These sovereign individuals decided to write their God-given rights on paper to preserve them forever, thus, they created the Constitution. They appointed sworn fiduciary trustees to protect these rights. These trustees formed what we know as government, operating under constitutional authority. However, over time, the integrity of this compact has eroded, and many now operate under a system that converts rights into regulated privileges. The public must critically examine how and why this transition occurred. 3. The constitutional principle, rights versus privileges. A fundamental legal truth is this: no state may convert a right into a privilege and demand a license or fee for its exercise. Refer to Murdoch v. Pennsylvania, 319 U.S. 105. If such a conversion occurs, the citizen may lawfully ignore the license or fee and continue to exercise the right with full legal immunity. This principle is reinforced in Shuttlesworth v. Birmingham, 373 U.S. 262. It is unconstitutional to punish anyone for exercising a protected constitutional right. For further reinforcement, see Miller v. United States, 230 F.2d 486, and United States v. Bishop, 412 U.S. 346. The prosecution must prove willfulness beyond reasonable doubt, which becomes impossible if one relies on legal precedent or counsel, eliminating any lawful cause of action. 4. The people must know their rights to assert them. The Constitution must be interpreted in favor of the citizen. Refer to Byers v. United States, 273 U.S. 28 and American Jurisprudence 2nd, Constitutional Law Section 97. However, to defend rights, individuals must first understand them. Government institutions have no incentive to educate the public about their constitutional protections. It is every person's responsibility to know and assert their rights. 5. Constitutional Driver's License Declaration. A sovereign citizen has the right to travel freely, without encumbrance or licensing, provided such travel is not conducted for commercial purposes. See Shapiro v. Thompson, 394 U.S. 618. The exercise of this right does not require a license, fee, or permit when performed by a private citizen traveling in a private capacity. The case Marbury v. Madison, 5 U.S. 137, 1803, supports this doctrine and remains legally valid. If a state mandates licensing in contradiction to this right, that mandate is unconstitutional and null. Any charge or citation issued under such regulation is a trespass upon the sovereign citizen and violates the supreme law of the land. 6. The legal framework for common law travel rights. Citizens retain all rights under both U.S. and state constitutions. No agreement or contract has been voluntarily entered into that relinquishes these rights. Furthermore, the burden of proof for criminal willfulness lies solely with the prosecution and cannot be met when a person relies in good faith on legal precedent. See Zobel v. Williams, 457 U.S. 55. 7. Conversion of rights into crimes is legally void. Any state law that converts the exercise of a basic right into a criminal act or privilege is void. Such laws are repugnant to the Constitution and should not be enforced. No court is required to uphold such fictions, and no citizen is obligated to obey them. 8. Legal notice to authorities. This document serves as constructive notice that the undersigned claims all constitutional rights as inviolate. Any attempt to infringe upon those rights constitutes trespass and will be prosecuted to the full extent of the law. Ignorance of the law is no excuse. The remainder of the document is a form declaration affirming the citizen's sovereign status, their rights under the Constitution, and official acknowledgement by county clerks or notaries.